Law 578, Law of Evidence 2, Lecture 3, Witnesses and Corroboration. Assalamualaikum warahmatullahi wabarakatuh. Okay, we are going to look at issues relating to witnesses and corroboration. In our previous lecture, we have basically discussed what is the concept of corroboration. We have discussed several witnesses that require corroboration, and we understand of the fact that corroboration can be corroboration as a matter of law and corroboration as a matter of practice and prudence. We have discussed in our previous video the position of an accomplice giving evidence in the court, whereby the law says that an accomplice is a competent witness to testify in the court. You have that in section 133 of the Evidence Act. An accomplice, however, in relation to corroboration, the law says that they are not worthy of credit. That is the presumption provided for under section 114 subsection B or 114 illustration B of the Evidence Act. They are not supposed to be 100% trusted. Therefore, under the law, however, there is no need for you to have his evidence corroborated by virtue of section 133. They are now require corroboration warning. In continuation of that evidence of an accomplice, we are going to look at evidence of accessory after the fact. Now, accomplice, according to the case of Davis against DPP, accomplice will be persons involved in the commission of the crime. Accessory after the fact, however, is not to be regarded as an accomplice. If you refer to the case here, basically, accessory after the fact is referring to a person who are initially not concerned with the commission of the crime, who does not even aware of the intention of the accused person to commit the crime. He has no knowledge of the commission of the crime. However, he might be there at the scene of the crime watching the accused person commits the crime, and he may be involved in disposing of evidence after a crime has been committed. Right? He is therefore be regarded as accessory after the fact. His involvement in the commission of the crime basically after the crime has been fully committed. And basically, if you look at the case of Harcharan Singh, there are two kinds of accessory after the fact. They are active accessories after the fact. So this will be a person who may have looked at the accused person committing the crime and may actively involve in disposing of evidence. And you have another person who will be a passive accessory after the fact. Yeah. Now, the law relating to corroboration in relation to evidence given by accessory after the fact is that, a person who is an active accessory to the fact, according to the case of Harcharan Singh, evidence has to be corroborated. According to this particular law, basically, when an accessory giving evidence in the court, his position has to be considered in line with the position of an accomplice. So they have to be treated as if it is an accomplice. So there's a presumption of unworthiness of an accessory after the fact's evidence similar to that of an accomplice. Therefore, if he is an active accessory after the fact, his evidence requires corroboration. However, according to Harcharan Singh, if he is a passive accessory after a fact, then only corroboration warning is enough for you to basically listen to his evidence. Alright? So there are quite a number of cases that talk about example of active accessories after the fact. You have the case of Harcharan Singh. You have the case of Francis and Donisami. In these two cases reflect that accessories after the fact here who later become a witness are very, very actively involved in subsequent commission of a crime or in the aftermath of a commission of a crime, in the sense that they are the person who basically maybe dispose of the evidence. Right? Now, so if you look at the PowerPoint here, you find that the requirement of corroboration is needed if accessories after the fact is actively involved in the commission of the crime, and corroboration warning is required if you have passive accessories after a fact. Now, the second category of evidence that you are going to look at will be the position of an agent provocateur. Now, who is an agent provocateur? If you look at this note here, Agent provocator will be someone who provokes or suggests the commission of a crime to another person with hope that the other person here do what he suggested and committed the crime as he suggested and therefore got conviction for it. So what happened here is that when you talk about an agent provocator, this will be a person who actively incites an accused person in the commission of a crime, right? So they are both, agent provocator and the participants here of the crime, which later becomes an accused person. They are both actively involved in the participation, so in the commission of the crime. However, the person is regarded as an agent provocator because in reality, even though he actively involved in the commission of the crime, in reality he is agent for the authority. So he can be an agent for the police, for example. Now why is the law recognize the position of an agent provocator? If you look at the PowerPoints here, they can be, in some cases, it's very difficult for you to get an evidence, especially like in drug cases or in bribery cases, because the manner in which the crime is committed basically involves element of secrecy and also involve element, I scratch your back, you scratch my back, both of the parties benefit. So it's very difficult for you to get an accused person. So what happened? Because of the nature of this particular crime that is being committed, you need to have someone who is an insider, right, to commit a crime or to incite the accused person in committing the crime. Not to say that the accused person is actually just committing a crime for the first time when he is caught. So this is a situation where you have an accused person who is a habitual offender, but very difficult for you to capture him. Because of the difficulties of capturing him, you require the service of an agent provocator to provoke for you so that the authority can set a trap to capture the accused person. So that is why agent provocator is basically needed. Now, when you look at the cases that look at the position of agent provocator, there is a need for you to basically distinguish agent provocator from an informer, especially when you are dealing with drug cases. Now, when you talk about an informer is a person who are protected by the law. So in case of drug, we have the Dangerous Drug Act, whereby the identity of an informer here will not going to be disclosed to anyone. An informer is not necessarily have to give evidence in the court. Therefore, when the prosecutor did not call an informer to testify in the court, Section 1143, subsection G, that is invocation of adverse inference, cannot be made on the prosecutor. So the law has provided some kind of protection to an informer, not to disclose the informer's identity. Now, who is an informer and how do you distinguish informer from an agent provocator? You basically have this in the case of Munusami. You can distinguish Munusami against PP and the case of Hussein bin Muhammad against PP, whereby a person will be regarded as an informer if he is only involved at the initial stage of the crime. So if you have a person who is an informer, his role is actually to introduce the agent provocator, who, for example, an undercover police officer, to the accused person. So that will be the role. So he introduced, and then the rest, the negotiation, the meeting, even the actual commission of the crime will be done by the agent provocator. Will be done by the agent provocator without the active commission or without the active involvement of the informer. So that's why in the case of Munusami, the court regards the person to be an informer because this particular person only involved at the initial stage of a relationship between an agent provocator with an accused person, that is by introducing an accused person to the agent provocator, right? So up until that stand. However, in the case of Hussein bin Muhammad against PP, the informer here was not called to give evidence in the court. However, the accused lawyer here is disputing the position of an informer, whether he is really an informer or not. Why? Because in the case of Hussein bin Muhammad, the so-called informer that introduced the agent provocateur to the accused person, also the one actively involved in arrangement of the meetings. He was the one who negotiated as to how much the price of the drug, and in this case the court says that since the informer here is actually actively involved in the meeting, in the setting up of the meeting basically between an agent provocateur and the accused person, the court says that this is not an informer. So if this is not an informer, basically what happened here is that he must be called to give evidence in the court, and failure to call him to give evidence in the court, section 114G, adverse inference can be invoked on him, right? So that is basically the position of an informer, right? So now there's also need to look into the distinction between agent provocateur and accomplice, yeah, because when you are an agent provocateur, you are basically working with the authority that actually have the knowledge of the fact that you are working with them. So basically you are gathering evidence with them because you are willingly involved in the commission of the crime. Without the knowledge of the authority of the fact that you involved in the commission of the crime is on their behalf, you may be regarded as an accomplice. So how do you distinguish an agent provocateur from an accomplice? You have here the case of an Indian case of Emperor against Chaturbhuj Sahu, whereby a person is regarded to be an agent provocateur when he, who later became a witness, made himself an agent for the public prosecutor before the commission of the crime. So you have a situation, for example, here, right? So you have a situation where, so you have, this is an agent provocateur. So this is a crime which is alleged to have been committed. So what happened here is that the agent provocateur basically has informed the police officer, for example, as to possible commission of the crime, and he will become the agent in gathering the evidence or capturing the accused person in the commission of the crime. Right? You may have this in cases of bribery. For example, what happened in the case of bribery? You may have a situation where, all right, so the facts and issue here is whether A commits bribery, so he's trying to gather or obtain some kind of benefit from the witness here. So maybe in form of gathering or obtaining benefit in approval of a contract. So what happened here is that, all right, A here may want to get some money from W. W was not happy with that. So W basically reported the matter to the MACC officer. So the MACC officer now will lay down a plan as to how to capture the accused person here. So the MACC here will basically maybe ask W here to make a phone call, and the phone call will be recorded and arrange for a meeting, right? And then eventually on that particular day when they met, the MACC officer is going to ambush them. So this is a situation where even though at the initial stage W here is not basically W here is not making any contact with the MACC, but after the initial stage, the subsequent action, W here is being in contact. In this situation, W here is basically an agent provocateur, right? Because now the officer here has knowledge of the fact that you are helping to capture the accused person. And it is not going to be an accomplice, it's not going to be an agent provocateur if what happened here, right? The commission of the crime has been completed, right? And only then he is informing the authority as to that. So what happened here is that you have a situation where W here already bribed. So you may have a situation here, A approached W requiring for some kind of money. So W paid it first. Actually, if you look at the definition in the common law case just now, this is not an agent provocateur because W has made the has completed the action. However, this might be different slightly in the case of bribery, because when you talk about W here, okay, say for example, maybe an accused person here says that, okay, W was stopped for committing traffic offense, and the accused person here said to W, you pay me some kind of cash and I will forgo the offense here. You are not going to be charged further on traffic offense. So what happened here? W pays some kind of cash to the accused person. So W basically has committed the crime. Now, if you look at the definition in the case of Chaturbhuj just now, if you look at the definition in Chaturbhuj here, you find that if W only extends the aid to the prosecutor after the offense has been committed, he is basically an accomplice. However, in the context of bribery case, the law under the MACC can say that if you are giving evidence after a commission of a crime, then you may not be regarded as an accomplice. You may be considered as an agent provocateur. So you have a situation where maybe you are a complainant in this particular case. So what happened here? W here now has paid some cash, so he will not going to be charged as a co-accused in this situation. There's some kind of protection given by him for making a report there. Okay. Now, when you talk about the law relating to agent provocateur. Now, agent provocateur, according to the case of Teja Singh here, right? Evidence of an agent provocateur is not that of an accomplice and does not require corroboration, right? Under the provision in the DDA and under the provision of the MACC Act, there is no presumption of unworthy of credit for evidence of an agent provocateur. So this particular law reflects the different position of an agent provocateur as compared to an accomplice, even though roughly when you look at the action of an agent provocateur and accomplice, basically they are the same, right? All right. So summarily, this will be the position of, let's look at the position of an accomplice vis-a-vis other witnesses or person. Basically, you have to understand accomplice will be a person who involved in the commission of a crime. However, he is not charged together with an accused person. He becomes prosecution witness. The law relation to corroboration basically says that corroboration warning is required when you are talking about an accomplice here giving evidence, because you have to read together section 114 illustration B with section 133 of the Evidence Act. So basically, dealing with accomplice evidence require corroboration warning. Corroboration is not mandatory. So when you talk about the co-accused person here, right, okay, co-accused person, right, we are going to look at co-accused person evidence after this. A co-accused person will be a person who involved in the commission of the crime together with the accused person. So when you talk about accessories after the fact will be a person who may not be at the initial stage involved in the commission of the crime, but in the aftermath of commission of a crime, he may be involved in destroying of evidence. So he is accessory after the fact. An agent provocateur will be a person who basically involved in the commission of a crime. However, he has signified his willingness to be working with the authority. So he now becomes the agent for the authority. So the law relating to corroboration does not apply in agent provocateur. Corroboration warning is applied if you're talking about accessory after the fact who are passive. Corroboration is required when you are dealing with active accessory after a fact, right? Now, hostile witness. So who are hostile witness? Hostile witness basically refer to a person who gives evidence in the court. However, this particular person, when he gives evidence in the court, he is now giving evidence which are adverse to the party who calls him, and he is actually also regarded to be a hostile witness if he is departing from his previous oral or written statement. So what happened here is that, right, when you talk about a hostile witness, remember when we talk about the law relating to calling of witnesses, you basically have under the Evidence Act, a person who call a witness will have to do the examination in chief, and the person that you call will normally be giving evidence to support your case, right? So that is the position of witnesses here, right? So you have, say for example, this is a prosecution case. The prosecution is going to call the prosecution witnesses. The reason why the prosecutor called these prosecution witnesses, because these prosecution witnesses is giving evidence in favor of establishment of actus reus and mens rea, yeah, of the charge that he is relevant. So if you have, for example, Ali is in charge for the murder of Mona. The prosecution witness here will be giving evidence that are relevant to show that Ali killed Mona, right? So that is normally the position of the law. And the prosecutor here will do the examination in chief. The cross-examination will be done by the defense lawyer, and re-examination will be done by the public prosecutor. Now, what happened when you are dealing with a hostile witness? When you are dealing with hostile witness, here, now what happened here? Your witness that is supposed to be giving evidence in your favor here is now giving evidence adverse to you. So basically, instead of giving evidence in support of actus reus or mens rea, right, the prosecution witness here is giving evidence not in favor of you. So he become hostile because he is giving evidence adverse. That is not to the advantage of the prosecution case. A person can be regarded to be an hostile witness also when, initially he has made a statement. Say for example, this particular person has made a section 112 CPC statement. So this is a witness statement indicating that maybe Ali commits the crime, he killed Mona. So what happened is that during trial, during examination in chief, it was discovered that the evidence given by PW here is contrary to his witness statement, right? So these are the position where he will be regarded as an hostile witness. Now, when we talk about him being a hostile witness, the law relating to a hostile witness here, basically, as I told you just now, the examination in chief will be done by the person who calls this particular witness. So if you have it at the prosecution stage, you are dealing with prosecution witness, the examination here is done by the public prosecutor. Now, under section 145, right, when you are dealing with a hostile witness, this particular person here now, instead of examination in chief, but during the examination in chief, he can basically be cross-examined, right? Remember, the prosecutor is supposed to do the examination in chief, but if his witness now turn hostile, instead of doing an examination in chief, he may treat the prosecution witness here as if he is the witness for the defense, in which he can cross-examine, right? So that is the position of an hostile witness, right? So now let's look at the position of a hostile witness here. So you basically have that you can cross-examine a hostile witness. The rationale of the principle of relating to hostile witness is that a witness that the party called will normally give evidence in the favor of the case of the person who called. Therefore, if it goes contrary to that, it's going to be very difficult, because the law says that since we are having adversarial system, whatever given by our witness is going to be binding on you, right? Now, the next notes here basically reflect that when the situation is regarded to be hostile, and what will happen if you have a hostile witness, right? If a person is now regarded as hostile witness, he can be cross-examined by the person who calls him, and it can go up until the process of impeachment. So impeachment is going to be the last process in which, if you have an hostile witness, you are going to challenge the credibility of the evidence given by your witness now who has turned hostile. So you have to proceed on to look into the impeachment proceeding, that is to impeach the credit of your own witnesses. So basically, the law relating to impeachment here is provided for under section 154 to 155 of the Evidence Act. Next, we are looking at evidence of co-accused as a witness against an accused person. So what will happen here in this situation, we are basically having a co-accused here giving evidence for the for himself at the defense stage. So this is a situation where you have, let's see, right? Remember, you have accused 1, accused 2, maybe they were involved in trafficking of drug. Accused 1 here is represented by lawyer number 1. Accused 2 here is represented by lawyer number 2. What happened here is that, of course, at the prosecution stage, you're going to have the prosecutor calling prosecution witnesses, and you have the process of examination in chief, cross and re-examination. And at the defense stage, what happened here is that, right, accused 1 or accused 2 can become a witness for himself. He can give evidence for himself, and he can also give evidence against the co-accused. So what happens if, for example, in this situation at the defense stage, A2 now is on stand. He is willing to give evidence on oath. And what happened now when he gives evidence on oath? He is giving evidence implicating A1, which is the co-accused, right? So if an accused person here, a co-accused person here, A2 is giving evidence implicating A1, who is his co-accused, do you need to have corroboration or not in relation to his particular evidence? Right, remember, both of these persons are giving evidence at the defense stage. Basically, whenever accused 2 here, co-accused here, giving evidence in the court on behalf of himself, he must not be regarded as an accomplice. So he is not an accomplice. Therefore, the rules relating to corroboration of an accomplice does not apply to him in this position. So it's very different from accessories after the fact. Accessories after the fact, you've got to treat them like an accomplice. Therefore, the rules relating to corroboration of an accomplice can be extended to accessories after the fact. But that is not so when you are dealing with a co-accused giving evidence at the defense stage against another accused person, right? So he is not to be regarded as an accomplice. However, does his evidence require corroboration or not? Now let's look at the law here. According to Dawood against Awanga, right, you have basically 4 persons here involved in the commission of the crime. Now, A1 here basically give evidence implicating A2 and A3, which are consistent with the prosecution case. It was held that A1 here is not an accomplice, and there were no rule of law that requires his evidence is to be corroborated. So in this issue, therefore, we'll find that a co-accused evidence does not require corroboration. However, as a matter of prudence and practice, corroboration warning has to be administered by the court. Right? So up until now, we have basically discussed few witnesses that relating to when they give evidence in the court. We found that a child witness, it is depending on whether the child understands or not the nature of an oath, then the child may give sworn evidence or unsworn evidence. If the child is giving unsworn evidence, the law says that corroboration is mandatory. Yeah, corroboration is required as a matter of law, right? So when you talk about victims of sexual offences, what will happen here is that corroboration warning is required evidence of victim of sexual offences, as a matter of prudent and practice, need to be corroboration, but corroboration is not required as a matter of law. So what you need basically corroboration warning. Similarly, in accomplice cases, you have presumption that they are not worthy of credit. However, their evidence require corroboration, and according to case law, eventually you'll find that corroboration on issues of accomplice here is only required as a matter of prudent and practice. Corroboration warning becomes mandatory. Yeah. Accessory after the fact, in the similar position of an accomplice, depending on whether they are active accessory after the fact or passive accessory after the fact, then corroboration basically required on active accessory after the fact, but corroboration warning is required if you are passive accessory after the fact. There is no issues of corroboration for agent provocateur. They are competent and credible witness. Hostile witness, basically, alright, this is issues relating to hostile witness here. You've got to see issues of his credibility is actually an issue. And co-accused person here, when you talk about a co-accused person, there is no need for you to corroborate his evidence, but corroboration warning is required as a matter of prudence and practice. Okay? So this basically is the discussion on issues of witnesses relating to corroboration. I think that's all for this video. See you next time.